state appears through District Attorney Kevin Schmidt in person. Mr. Matrius appears in person without counsel. We're set today in this matter for a status conference. Mr. Matrius, you were very close doing the steps to get your license.
Yeah.
Where are you now?
I got my appointment for enrolling until August 7th.
Well, it's scheduled, so that's good. August 7th, and then hopefully you won't have too much to do after that. I'm going to schedule you for that September 29th at 11:45, the same I did with Miss Julene. If you have your license, bring it to the state prior to that, and then you should not need to come to the next hearing.
Okay.
So come get your notice. You're free to go. Thank you. Mr. Marco, can you hear me?
I can.
Mr. Keene has a trial going on right now. I don't know why St. Croix didn't show.
Okay.
Is Mary gonna take care of that? Yes.
Mr. Patton, is that you on the telephone? You are muted. And I also have Doug Mitchell. Mr. Patton, is that you with the telephone number 612-669-4542? You are muted.
Sorry, Judge, I'm here.
Okay, thank you. We will go on the record in the matter 25 CF 45, State of Wisconsin versus Dennis Olsen. The state appears through District Attorney Kevin Schmidt in person. Mr. Olsen appears in person with counsel Michael Patton by telephone with approval of the court. We're set here today in this matter for a status conference. Mr. Patton, can you please update the court? We do have a speedy trial requested, and it has been set for September 3rd. I believe it's for 3 days. I can't recall, or 1 day. Yeah, 3 days. All right. So, Mr. Patton, can you please update the court?
Yes, Your Honor, my client is intending to proceed to trial on the.
You're cutting out.
Can you hear me better?
No, I cannot.
Well, I'm stopped.
Oh, now I can hear you better.
Okay. Yes, we're
But now I can't. I'm gonna guess. I think you said your client wants to proceed to trial.
That is correct, ma'am. Yes.
Excellent. Okay. Has an offer been presented, Mr. Schmidt?
Yes, the offer made in this case would be a DJOC on the charges alleged, requirement to pay back the restitution. If he successfully completed the DJOC, then it would result in a disposition of misdemeanor theft for costs with no jail and no probation.
All right. So, Mr. Olsen, I'm going to explain what that is to you so you can understand. Then you can talk to your attorney, or he may have already done so. A DJOC, it's a deferred judgment of conviction. That means that the state is asking that you plead to the felony, but then it would be a deferred judgment of conviction. It just kind of hang out there. All right. It just be out there. And if you pay the restitution, you're not in any type of, you don't get any other criminal charges, you remain sober, then that felony goes away. All right. It comes off of your record and it goes away. And then it would be amended to a misdemeanor theft for court costs. That's it. No jail, no probation. That would be the recommendation to the court. So up front, it would be pleading to that felony charge. But again, it goes in like it's a contract with the state. It says that if you do all of the things, which would be remain sober, you might have to have an assessment or something, paying the restitution, not getting into any other criminal conduct or activity. After that period of time, that felony disappears and it goes away. All right. So then it would be a misdemeanor theft, again, with a non-jail recommendation. for court costs only. And for misdemeanors, that's $443. So that's what the recommendation is, or the offer is, I guess, okay? Because if we proceed to trial, and right now the trial is a Class G felony, theft in a business setting greater than $10,000, less than $100,000. I don't know what the allegations are. I don't know what's being alleged as being the amount or whatnot, but that's what's charged, a Class G felony. If it goes to trial and you are convicted of that by a jury of your peers, burns on the state to prove beyond a reasonable doubt that you committed this or a lesser included, which would be something that could be a stage less than this. But if you are convicted of this in a jury, most likely the date of the jury trial, your bond will be revoked. You'll go right to jail to sit until sentencing, okay? And with a Class G felony, if you are convicted, it could mean a fine of up to $25,000 or prison of up to 10 years, okay? So that is what's at stake, and that's the offer from the state. So you need to think about that and talk to your attorney about that, get your options and what it is that you're thinking and all of those things. Again, we have the jury trial scheduled for 3 days beginning September 3rd. All right. And again, if convicted on that date and time, you will most likely immediately go to jail and sit until sentencing. Okay. All right. So talk to your attorney. We have a final pretrial on August 12th. Okay. August 12th is what's called the final pretrial. That's where we talk about all of the things that we need to be ready for that jury trial. On August 12th, that's the last date to reach any agreement with the state. I accept no other offer after that, no other agreement after August 12th. It will go to trial, okay? So that's where we are with that, all right? So, Mr. Schmidt.
I thought the status was set to address my motion to continue.
Oh, right. And we also do have your motion to continue as well.
Can I make a suggestion, Your Honor?
Yes.
Can we address the motion to continue on August 12th?
No.
Okay. Okay.
This court doesn't work that way because I have a lot of respect for my jury and for my jury pool. And for my staff, it takes a lot to get a jury together. And I would need to know by August 12th if the matter is going to reach an agreement or not. And then we will proceed to jury on September 3rd. That's not going to be long enough. I can reset the motion to hear the motion for continuance for another date and time here somewhere shortly. However, we need to get this matter figured out.
What I was saying, Judge, was I wanted to talk to counsel because I think we could potentially reach a stipulation on that issue. That's all.
Oh, that's fine. If you want to reach a stipulation on that, or you want to see if you can, that is completely fine too.
Yeah. So would you, if let's say hypothetically the motion still had to be heard, are you suggesting a date earlier than August 12th?
Yes.
Okay. Well, we can get a date, but I'm pretty confident I can reach an agreement with counsel on that motion. But yeah, if that makes sense.
All right, that does make sense. So my thought would be August 4th at 10:15.
Okay. That's fine with me, Judge.
All right, so August 4th at 10:15, they'll come back to court. Your attorney may want to talk to the state to see if we're going to, or have the ability to reach an agreement on whether or not to move the trial, even just for a little bit. So talk to Mr. Patton, your attorney, about all of the things, the trial as well as the agreement, okay? Not agreement, the offer.
sorry, Judge, didn't mean to cut you off. I wanted to call counsel a little later today. Is it okay if I get his phone number?
Yes, it's 715-349-2167.
Okay. Uh-huh. All right. Thank you, ma'am.
All right, anything further?
No,
Not
ma'am.
for me.
All right, August 4th, 10:15. Okay?
Thank you.
Yes, here.
All right, let's talk about that. The status hearing in State of Wisconsin versus Dennis Olsen had all the ingredients of a quietly high-stakes courtroom moment. No drama, no outbursts, but beneath the calm was a real sense of weight. Mr. Olsen, charged with felony theft in a business setting, appeared by phone with his attorney, Michael Patton, while District Attorney Kevin Schmidt was present in court. The state's offer? A deferred judgment of conviction, DJOC, restitution, and, if completed successfully, a reduced charge with no jail and no probation. Sounds generous on paper, but as Judge Mogen made clear, the stakes couldn't be higher if Mr. Olsen turns it down. Let's break that down. The DJOC means Mr. Olsen would plead to the felony, but the conviction would be hanging, not final. If he paid restitution, remained sober, and avoided any new legal trouble, the felony would be wiped and replaced with a misdemeanor theft conviction, costing him just court fees. Pretty clean outcome for a Class G felony, which typically carries up to 10 years in prison and $25,000 in fines. And Judge Mogen didn't soft pedal it if Olsen went to trial, was convicted, and that conviction landed, the court would likely revoke his bond on the spot and remand him into custody until sentencing. Olsen, for his part, was respectful and engaged. There were no objections or pushback. In fact, he asked to speak with the state and seemed interested in reaching a stipulation on a motion to continue. His attorney confirmed that they were likely to reach an agreement before the next hearing, which suggests that while a trial is technically still scheduled, both sides may be working toward resolution. Judge Mogen, ever direct but respectful, reminded everyone that the final pretrial is locked for the 12th of August. No plea deals will be accepted after that. Come the 3rd of September, it's trial time. There was also a little moment of lightness when DA Schmidt thought they were just there for a status update, not to handle the motion. Judge Mogen wasn't having it. "This court doesn't work that way," she said, half laughing but fully serious. I have a lot of respect for my jury pool. It was a nice reminder that while Judge Mogen runs a tight ship, she also brings a human touch even in cases with serious consequences. So where does that leave things? With a defendant at a crossroads, Mr. Olsen can accept the DJOC and meet some reasonable conditions to avoid a felony conviction or take his chances at trial, where the outcome could be far more severe. The 4th of August is the next stop, and by then, we'll know if this is heading toward resolution or trial prep. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.